What you're about to watch is not just a routine court date. It is a full-blown courtroom collision between sympathy, accountability, addiction, bond violations, and a judge who is clearly running out of patience. At the center of this hearing is Candace Kelly, a defendant facing not just a pretrial conference, but also an arraignment on a second amended bench warrant tied to repeated bond violations. And from the jump, the allegations are serious: missed or untimely testing, unreported prescriptions, and multiple positive tests for THC and amphetamines, including a positive result the very day she walks back into court. That is already a bad start. But what makes this case really compelling is that it is not just about failed compliance. It is about whether the court sees a defendant struggling through grief and trauma, or a defendant who keeps breaking the rules and then showing up with one explanation after another. Now, here's where the stakes get even higher. There is also a possible resolution on the underlying domestic violence case. The prosecution is willing to recommend a deferral if she enters a no contest plea. In plain English, that means she had a path, maybe not a perfect one, but a path to avoid the harshest outcome on the actual charge. But before the court even touches that deal, the judge makes it crystal clear: bond performance comes first. And that is huge, because if you cannot follow court orders while you are already being given a chance, why should a judge believe you will suddenly become compliant on probation later? So as this hearing unfolds, listen for the real tension underneath the legal language. Is this a woman drowning in personal tragedy and substance issues who genuinely needs treatment and structure? Or is this another courtroom story where excuses keep arriving faster than accountability? That question is going to hang over every answer, every admission, and every ruling in this case. And by the end, the judge is going to make a decision that says exactly where he stands.
All right. This is case number 254914SM, the people of the state of Michigan versus Candace Ann Kelly. Appearances, counsel.
Please sit all for the people.
James Dick on behalf of Ms. Kelly, Your Honor. She's sitting to my right.
All right. We are here for a couple different matters. One is a pretrial and the other is an arraignment on a bench warrant. So we will handle, actually it looks like a second amended bench warrant. So we will handle the arraignment first. Well, Ms. Kelly, I have a bench warrant that alleges the following: that you are in violation of your bond for failing to submit to a test on November 25th of this year, that you failed to appear for drug tests as ordered between the November 25th and December 9th, that you failed to report a prescription, and that you tested positive for amphetamine and THC on November 25th through the 9th of December. And not part of the bench warrant, but we had you tested today and you tested positive for amphetamine and THC. Back at arraignment on the 21st of November, the court had ordered no, among other things, no controlled substances, including recreational marijuana testing. You do have the right to have a contested hearing regarding that bond violation, where the prosecution would have to present evidence to determine whether or not you are in fact in violation of your bond conditions. Do you understand that?
I do.
Mr. Dick, how does your client wish to proceed regarding the bond violations?
Your Honor, for the purpose of the bond violations, she does want to accept responsibility.
Okay.
An explanation.
All right. And then I believe we also have a resolution on the underlying case. Is that accurate?
Yes.
Right away, the court spots the pressure point in this case. There may be a plea deal on the domestic violence charge, but none of that matters if the bond violations are bad enough to blow up the court's confidence. And that is a textbook judicial move. Before the judge hands out the benefit of a deferral, he wants to know whether this defendant has done anything to earn that trust. Because deferrals are not magic freebies. They are acts of judicial restraint. They are basically the court saying, I'm willing to give you a path forward if you show me you can follow rules. So when the judge says the bond issue could determine whether he follows the recommendation, that is not just procedure, that is the whole game. And from a viewer's perspective, this is where the hearing gets really interesting. The defendant is trying to accept responsibility in some form, but the court is already sensing there may be a gap between I'll take responsibility and I'm actually admitting what happened clearly and truthfully. That gap matters. In court, partial admissions with unclear facts can unravel fast. So the question becomes, is she stepping up honestly, or is she hoping to keep the plea deal alive by softening the bond violations just enough to survive the hearing?
And that would be?
Your Honor, the people have offered that if Ms. Kelly were to plead domestic violence, we
We would recommend that for a deferral.
Is that a guilty plea or a no contest plea?
It will be a no contest, Your Honor, due to alcohol consumption, I believe, with PBT, and the police report reflected today, pointed to.
Have the police report for approach.
Sure. Just want to double check something there. Let's handle the bond violation first, because that could be determinative as whether or not I'm going to follow the recommendations of the 4A. So, Ms. Kelly, is it true that as you were aware that as part of the bond conditions, you were supposed to test as ordered?
Yes, Your Honor.
And you were not to consume, I forgot to swear you in, please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. And that you were not to consume controlled substances, including marijuana. Did you understand that?
I did not fully understand that I was not allowed to use, I was under the impression it was recreational marijuana.
Do you have a card?
I do,
All right. Is it a valid card?
it is.
Did you provide that to community corrections?
I have not.
Why not?
I just figured because I knew that I was gonna come out positive for marijuana, and so I figured that I would provide it at this time. I haven't gotten an actual copy of my card. I did apply for it because I knew that with being on probation,
When did you apply?
the day after I was released from jail. I've had one in the past, but with marijuana becoming legalized, I didn't renew my card. And then once I was put on probation, then I renewed it.
Do you have proof with you today?
It's on my phone.
I have a copy of the approval, and a picture on my computer.
Just what's the date of the approval?
The actual approval, the email shows that it was sent.
This is the first major turning point, and you can almost hear the judge's patience snap into focus. The defendant tries to explain the marijuana issue by saying she did not fully understand the restriction, that she had a medical marijuana card, and that she planned to provide proof. But once the court starts digging, the timeline gets shaky. She says she had not submitted the card to community corrections. Then we hear the approval email was dated December 3rd. Then she suggests she applied right after getting out of jail. And then, when the court asks about a missed or failed test date, the answer shifts again into uncertainty about receipts and whether she really missed anything. That is exactly the kind of moment judges hate. Not necessarily because the defendant is lying outright, but because the story starts to feel slippery. And then comes the line that changes the energy of the whole hearing. The judge says, "I'm not going to take a plea. We're going to have a hearing on this." Translation: the court is no longer interested in a broad, tidy admission wrapped in explanations. The judge wants specifics, dates, proof, and clarity. In other words, the excuse fog just met a legal leaf blower. And once that happens, defendants usually have one of two outcomes. Either the facts clean up fast, or they get worse.
On December 3rd of this year, saying that she has been approved and she should receive her card within 7 to 10 business days. That this is a temporary substitute for the card and is only valid for 30 days from the date of receipt.
Does it indicate when the application was submitted?
It does not, Your Honor.
Is it true that you failed to submit to a drug test on November 25th of this year? Or
What
a
day was
test?
that?
That would have been a Tuesday. The Tuesday before Thanksgiving.
I don't think I had a receipt for that day because something happened to it. I've never missed a drug test or an alcohol screening.
All right, I'm not going to take a plea. We're going to have a hearing on this. Ms. Dahl, are you prepared for a hearing?
I don't have the community corrections officer here.
She's right there in the back row.
So
Oh, I'm so sorry.
may I have a brief conversation with her about that?
No, we're gonna have a hearing. We're gonna have full of excuses, so we're gonna have a hearing on this. Mr. Dick, do you need a moment to talk with her about a potential defense for the hearing?
I think. Just 2 seconds, right?
All right.
We just taken over this matter from the previous attorney who essentially quit his job yesterday.
Okay.
And this one particular date that you're asking about, we may be able to resolve that. I think there's a sufficient amount of ownership within the rest of the bond violation. If court would be willing to accept her responsibility to the rest of those. However, if that's not the case, I do ask that just afforded some time if not been in contact with the testing facility. So they actually have the confirmation for that particular day.
All right, Ms. Matsky, let me ask you some questions because it's not entirely clear in the petitions. So the petitions say that the bond violations, so for example, the one dated December 5th says that the alleged bond violations occurred on November 25th through November 30th. So that's a 5-day gap. Can we narrow down those dates?
It would be November 25th, November 28th, and November 30th specifically.
And then the one dated the 12th of this month alleges 11/25 through 12/9. So presumably that's going to be the 25th, 28th, 30th. And then are there some dates in December as well?
December 3rd. December 9th, 10th, 11th. As of now.
Those violations. So the only violations that the court had presented to us would have stopped then on, it looks like the 9th. Ms. Dahl, do you know, I see you signed this on the 12th, but you allege violations through the 9th.
Yes, Your Honor, I did get additional violations since that time, but I have not submitted them to the court yet.
Okay.
I think the issue we're having with the defendant is she is testing downstate. She is testing late, not according to the procedures given to her. She has to test by a certain amount, by a certain time in the morning. She's testing in the evenings. She's not providing proof that she tested timely, and then the results come later. So she's not testing as directed. So she's not testing in the mornings when she's told to, and she's not providing proof.
So are we, so I want to make sure we're clear on this. It's not necessarily so it is a fail to appear as ordered, but not that she didn't test, she just didn't test when she was supposed to.
Correct, and she's not providing proof of her testing at the time that she's supposed to.
Ms. Matsky, have you received proofs of these tests?
We have received
Now, this is where the hearing becomes legally fascinating because the court starts separating what looked like total no-shows from what may actually be a different kind of violation, late testing. That distinction matters more than people realize. At first glance, failed to appear sounds like she just skipped testing altogether. But as the court questions community corrections, the picture gets murkier. The issue seems to be that she did test on several dates, just not within the required morning window, and without promptly submitting proof the way she was supposed to. That may sound like a technicality, but in bond court, technicalities are the rules. If the order says test by a certain time, then testing later is still non-compliance. At the same time, this clarification does help the defense in one narrow way. It undercuts the idea that she simply vanished or refused to test. Instead, it paints a messier picture. Somebody partially complying, but doing it wrong, late, and inconsistently. And that is exactly why the judge says he is not sure whether the water has been cleared or muddied. Honestly, that is the perfect description. The state still has a violation, but now the hearing is less about total absence and more about repeated failure to follow directions precisely. Do you see that as a meaningful difference, or just a different flavor of the same problem?
results for most of them. I believe the violations started as a no-show because that's what it appeared to be as from our office, and then I believe we updated them as a late test. So it just gets a little bit murky when we're updating violations.
All right. So, Mr. Dick, does that, I'm not sure if that cleared the water or muddied the water.
I
But-
think, Your Honor, it clarified that what should be asked is whether she is going to accept responsibility or plead guilty to the fact that it wasn't as directed as opposed to not testing, which is, I believe, what was originally just asked.
All right. All right, we'll give it another shot. Before we do that, though, I need clarification then, Ms. Matsky, on what dates did she test positive on the 12th petition? It says positive for amphetamine and THC. Oh, hold it, I probably have it here. A second. So it looks like there was a positive, alleged positive test on the 30th. For amphetamines, THC. The 28th. 25th. You have labs, Ms. Matsky, do you have labs for the 3rd and the 9th?
The third amphetamines was negative, the 9th it was positive.
All right, so we'll try this again. Then Ms. Kelly. Is it true that you failed to submit to a timely test on the 25th of November? Pursuant
Yes.
to the rules.
It is, Your Honor.
And how was it not timely?
Because it states on the forms here that I have to test between Monday through Friday is from 11 a.m. till 10 a.m. I was under the impression that that was for PBTs, not ETGs, because I was under the assumption that ETGs, the alcohol stayed in your system for at least 24 hours. And I started taking ETGs daily once my machine broke. And they said not to return the machine, like not to send it back, because if it were to get lost in the mail, it does cost $1,200 to return it. I called this facility the day that I told them that it was broken, because when I blew into it, the little code came back. And it said test, like, it said something, it said a weird error that
So let's cut to the quick. Did you not test within the time frame allowed? That day?
Yes,
All right. Did you submit proof of testing for that day to community corrections?
believe I did. What I do is when I submit proof. Yes,
You submitted proof of that
I believe so, I did
that day?
that day.
On the 28th of November, did you also then test positive on the 25th for amphetamines and THC?
I'm sorry, what was that?
On the 25th, did you test positive for amphetamines and
Yes, Your Honor.
THC? And on that date, did you have a prescription for either of those?
Don't believe I did.
All right. But you provided it. So if you don't believe you did, you would not have provided a prescription to community corrections.
I did not provide my prescriptions to community corrections. You are correct.
On the 28th, did you test within the requirements?
I tested late.
All right. And did you test positive for amphetamines and THC that day?
I did.
And did you have a prescription for either of those?
No.
On the 30th, did you test outside of the testing parameters?
Yes.
And did you also test positive for THC and amphetamine that day?
Yes.
Did you have a prescription for either of those?
No.
On the 3rd of December, did you test outside of the testing time periods?
Yes.
Ms. Matsky, you said amphetamine was negative that day. Was there a positive THC that day?
Correct.
Did you test positive for THC that day?
Yes.
And did you have a prescription on that day?
Yes.
You did. I'll refresh my memory. When was that approved, Mr. Dick?
The 3rd, Your Honor.
You had not provided that to community corrections.
You're correct.
On the 9th, did you test outside of the testing requirements?
Yes, Your Honor.
Tested.
And here is the moment the hearing tightens like a vice. Because once the judge reframes the questions more precisely, the defendant starts making a series of admissions that are very hard to walk back. She admits she tested late on November 25th, late again on the 28th, late on the 30th, late on December 3rd, and late again on December 9th. She also admits testing positive for amphetamines and THC on multiple dates, and for several of those dates, she flatly says she did not have a prescription for the substances at issue. Even when she says she eventually had approval related to THC, she also admits she never provided that documentation to community corrections. Legally, that is devastating, because by this point, the court no longer needs to wonder whether there is enough evidence. The defendant herself is supplying it. And notice what happened strategically. Once the confusion over missed test versus late test got cleaned up, the judge did not lose the violation. He strengthened it. Why? Because a cleaner question got a cleaner admission. This is one of those courtroom lessons that happens over and over. Sometimes narrowing the allegation does not save the defendant, it just makes the proof easier. At this stage, the real battle is no longer whether she violated bond. It is what the court is going to do about it.
Positive for amphetamine.
Yes, Your Honor.
And did you have a prescription for amphetamine on that day?
No.
Ms. Matsky, was that also positive THC?
On the 9th,
Yes.
yes.
On the 9th, had you provided your prescription for THC to community corrections?
I did not, Your Honor.
Do counsel believe defendants provided a factual basis to accept the plea to the bond violations?
Yes, Your Honor.
Yes, Your Honor. And just as a formality, I'm not saying she is accepted. I don't see where I have a December 3rd retest on here. However, I do acknowledge that she said she was.
So,
Forgive me, I did take over this.
yeah, so on the violation marked, or that Ms. Dull dated the 12th, that's 11/25 through 12/9 are the violation dates.
Okay.
And those are the dates I went through with Ms. Matsky. Ms. Matsky, you did say the 3rd was one of those that she had missed, or that was late.
There it is. The court finds sufficient evidence of a bond violation, and the judge immediately reveals what is really bothering him. It is not just the individual positives. It is not just the late tests. It is the broader message those violations send about supervision. The judge basically says if she cannot perform while on bond, why should he believe she is going to perform on probation? That is a brutal but very common judicial calculation. Bond is often the court's early preview of future compliance. If a defendant cannot handle the simpler version of supervision, judges become deeply skeptical about giving them a more formal one. And now the prosecution takes a nuanced position that makes this hearing even more dramatic. On one hand, the prosecutor says flat out that the court should remand her today because the bond performance is terrible. On the other hand, the prosecutor still wants the court to consider a PSI, a pre-sentence investigation, because there may be important background explaining how this defendant ended up here. That is a very telling split. It says she earned immediate consequences, but we still think the full story matters before sentencing the underlying case. In other words, accountability now, context later. That is a sophisticated prosecution posture, and it tells you this case is not being treated as simple black and white.
I'm not,
Did I write it down
yes,
wrong?
it was at 5:10 PM.
On the 3rd.
Yes.
Okay. All right, the court does find that there's sufficient evidence to find the defendant in violation of the bond conditions. Counsel, I'm going to tell you right now, her performance on bond, I'm not going to go 4A with her. If she can't perform on bond, there's no way she's going to convince me that she's going to perform on probation. So,
Your Honor, may I speak?
okay.
I'm recommending that Ms. Kelly be remanded today regarding the bond violation, and I would ask that the court accept her plea, but refer her to get a PSI in this case. I believe the history behind her alcohol use that led up to the crazy events that happened that resulted in these charges is something that the court should consider and potentially may not know without a PSI. So I think with a PSI, the court potentially might consider a deferral, but we would ask the court to at least refer her to get a PSI so the court may have more background information as to why the people recommended the deferral.
Well, why don't you tell me why you're recommending the deferral?
Well, I don't know if she's okay with sharing it, is in the police report. She lost her son about a year ago, and she did not deal with that well. And she resulted, from what the police report says, she turned to drinking as a way to cope with her pain. And that resulted in the actions in this case. I'm not in any way condoning her behavior while on bond, and it was a continuous violation after continuous violation after continuous violation after continuous excuses from her. I do want to highlight.
This is the emotional center of the case, and the prosecutor handles it in a way that is both compassionate and ruthless. We learn that the defendant lost her son about a year earlier, and according to the report, turned to drinking as a way of coping with that pain. That is heartbreaking, and it absolutely matters. Courts are not blind to grief, trauma, or self-destruction after personal loss. But then the prosecutor pivots, and the pivot is sharp. She says she is not condoning the behavior on bond, and describes it as violation violation after violation after violation, followed by excuse after excuse after excuse. That contrast is powerful because it captures the core tension of the whole hearing. A tragic backstory can explain conduct, it does not automatically excuse it, and that is something a lot of people misunderstand about sentencing and supervision hearings. Judges will often listen to the pain, acknowledge the pain, even sympathize with the pain, and still impose custody if they believe the defendant kept choosing non-compliance. The prosecution is essentially saying, we see the trauma, we are not ignoring it, but we are also not going to pretend it erased the rules. And honestly, that is why this part of the hearing hits so hard. It forces everyone watching to confront a difficult question. How much grace should the system give when suffering and repeated violations are happening at the same time?
Like that she did test every time she was supposed to, even though not on the terms that she was required to. So I believe that she has the potential to abide by probation terms. I think that her background and with services, she might be able to be a good candidate for probation. So that's why the people are recommending a deferral in this case.
Mr. Dick?
Yes, Your Honor. So as it pertains to the deferral, we are asking that the court would accept that or would extend that. This, as mentioned, there is more background that we can provide to the court, stemming all the way back from the loss of her husband in 2013 to a suicide, Your Honor, which we haven't yet, you haven't yet taken the plea on the domestic violence charge, but all of this plays a part in what has been going on to this time, as well as the other attorney that was handling this matter has not been in contact with her about this to really figure things out. And some of the issues here, I believe, are either a lack of advice from the prior attorney or a lack of good advice. In this matter, Your Honor, as the prosecution said, she has tested when she's required to, although not within the parameters. One of the things that I'm going to specifically mention is the fact that she did have a breath machine that she was testing on, and she was testing properly initially during her windows that she was provided. It was after that, when she was doing the ETG test, that she would test in the afternoon. One thing that I can attest to the court about the providing the test to the court, I've practiced downstate for most of my career so far. The facilities generally do not give the testing.
Now the defense steps in and tries to do what good defense lawyers often have to do in the hardest cases: turn a pattern of non-compliance into a story of human breakdown, confusion, and treatable instability rather than defiance. Counsel points to grief, PTSD, the death of her husband by suicide years earlier, the more recent death of her son, substance abuse as a coping mechanism, and even the change in attorneys, with the previous lawyer apparently gone and communication having broken down. On top of that, he adds a practical argument about testing systems, receipts, breath machines, ETG testing, and the reality that facilities do not always give clients much documentation to work with. That is not a bad defense strategy at all. It is layered, it is human, and it gives the judge a theory that sounds bigger than mere irresponsibility. But it also has a weakness. Judges tend to separate explanation from compliance. They may believe every word of the trauma story and still ask the same question: why were the rules not followed? That is why defense counsel keeps returning to the idea that she was testing, just not within the exact parameters, and that she now wants accountability, counseling, and structure. He is trying to shift the court from punishment mode to intervention mode. The problem is, by this point, the judge may already be stuck on something simpler. How many chances does someone get before the court has to mean what it says?
Or anything to the clients, or much of anything. The receipts are provided in case the report isn't provided to show that they actually showed up.
Right.
And
which is why community corrections requests the receipts be provided.
I understand that. I understand that. And I think part of the issue here is with everything going on. Miss Kelly having her substance abuse issues since the loss of her son. She did have a quite a span of being like sober. However, having PTSD issues from her husband's death and having her son pass away here suddenly this past year. There's a lot of mental health issues that have arose, and dealing with it through substance abuse has been really the only way that she found she was able to get lost. So she's been alcohol free since this domestic violence incident. She's not tested positive for alcohol. I'm aware. She may have some other issues that she's been dealing with that she definitely needs, and stated that she needs the accountability to get through this. She also tried to schedule a appointment recently to get into some sort of counseling to deal with everything. She hasn't been sober since her son's passing. This time period right here is the first time that she's been able to get her mind at all focused on where she needs to go in life since then. With that being said, Your Honor, we are asking that she gets a second chance, fully knowing that if she violates any terms of bond or probation, that she could end up right back here in jail, serving ultimately the full sentence for the underlying charge or contempt of court. That being said, Your Honor, Ms. Kelly came here today knowing that she was potentially facing jail, just based on the bench warrant and the allegations from the bond violations. But she still showed up here today. Now, she lives downstate. She lives in Roanoke, and it is a bit of a feat to get up here. However, if the court would extend her the deferral, keep her on probation for a period, which she actually is welcome to be able to have some more accountability in her life, to get herself clean, to maintain her sobriety, and to make sure that she's getting the mental help and treatment that she requires to avoid any further substance abuse issues. Pardon me. And with that,
This is the defense's final emotional swing, and it is a smart one. Counsel tells the court that Candace Kelly showed up today knowing she could be taken into custody on the bench warrant. He points out that she came from downstate, that getting there was not easy, and that her appearance in court proves she is not trying to run from the process. That is a classic credibility argument. Whatever else she has done wrong, she did not hide from this hearing. She came in knowing the risk, and to be fair, that point is not nothing. Judges do pay attention when defendants appear instead of disappearing. But here is the problem. Showing up for the reckoning is not the same thing as having complied before the reckoning got there. That is the wall the defense is hitting. They are trying to frame her as somebody ready for one more chance, somebody asking for structure, counseling, sobriety support, and accountability rather than release from consequences. It is a compelling ask, but the judge is weighing it against a record that now includes repeated late tests, positive results, missing documentation, and a warrant that had apparently been floating around for days. So the question becomes, does courage at the end outweigh non-compliance at the beginning?
Your Honor, we are asking that the court declines to remand her today and perhaps give her one additional chance. And as I said, she showed up here today knowing she may end up in jail. So do not believe that there's any issues with her.
Now, this is a very important legal moment because the judge makes a careful move that viewers should not miss. He says he is not going to take the plea today, but he will order a PSI. That is not indecision. That is controlled caution. The court is basically saying, I want the full background before I decide whether I'm willing to go along with this deferral recommendation. And I'm not locking in a plea yet because if I reject the agreement later, the defendant would get a chance to withdraw it. That is smart judging. It preserves the integrity of the plea process while still gathering the information the court thinks it needs. So even though this may sound procedural, it actually tells you a lot. The judge has not slammed the door on the underlying case. He has not said, no deferral, absolutely not. But he also has not been persuaded enough to move forward on trust. He wants more facts, more history, more context, and probably more confidence that whatever happens next is grounded in something stronger than sympathy. In plain English, the plea deal is alive, but it is on life support. And what happens on bond in the meantime is about to tell you whether the judge thinks she deserves to stay out while that process continues.
Coming back to court.
All right, thank you. I'm not going to take the plea today, but I will order a PSI because I don't want to, if I take the plea and I don't follow the agreement, she's going to be given the opportunity to withdraw. So we won't do that yet, but I will order the PSI. In regards to bond, I have somebody, yes, who is not testing positive for alcohol, but they're testing positive for other substances that, at least in the beginning, they didn't have a prescription for. The court's not impressed that once it was ordered, she ran out and then got approval to use THC. But she also doesn't have a prescription for amphetamines. She didn't, even when she got approval, she didn't provide community corrections with the prescription for THC, her medical marijuana card, nor has there been any prescription provided for the amphetamine. Bench warrants have been floating around on this case since November 26th. So the fact that she presented herself today, knowing that there was a bench warrant, presumably knowing what was a bench warrant, the court's not impressed with that either, because for about 2 weeks, she must have known and then just didn't do anything about it. As far as a second chance, she had that chance on the 28th.
And there it is. The hammer falls. The judge remands Candace Kelly to the custody of the county jail, and the reasoning is as important as the result. He is not just reacting to one bad test or one missed deadline. He is reacting to repetition. He points out that she was given a second chance on the 28th, then again on the 30th, then the 3rd, then the 9th, and then there were even more dates not yet formally before the court. That is what finally tips it. In the judge's view, bond conditions only mean something if the court is willing to enforce them, and once he says that out loud, you know exactly where this is going. This ruling is tough, but it is legally consistent. Judges hate becoming suggestion machines. If they set conditions and the defendant keeps violating them with no real consequence, the court loses authority fast. So the remand here is the judge drawing a line. Enough chances, enough excuses, enough partial compliance. At the same time, notice the nuance. He still orders the PSI, which means the bigger story of grief, addiction, and possible treatment is not gone. It just is not enough to save her from custody today. That is the difference between sentencing mercy and bond enforcement. One looks at future possibilities, the other looks at present performance.
When she tested outside of the requirements, she 30th, the 3rd, the 9th, and then not presented at the court, but Ms. Matsky gave 3 more dates. I've got somebody, it does no good for me to order bond conditions if I'm not willing to enforce them. And so I am going to remand the defendant to the custody of the Wexford County Jail, and we'll get the case reset. Anything else for the record? All right, ma'am, you'll have to go with the bailiff.
What makes this hearing so gripping is that it never turns into a simple villain versus victim story. On one side, the court is dealing with a defendant who repeatedly failed to follow bond conditions, tested late over and over, tested positive for THC and amphetamines, failed to provide documentation to community corrections, and showed the judge a pattern of supervision problems that the court simply could not ignore. On the other side, there is a deeply painful personal history, the loss of a husband, the loss of a son, substance abuse connected to grief, and a defense argument that what this woman needs is not just punishment, but structure, treatment, and real help. Both of those realities existed in this courtroom at the same time. In the end, the judge drew a hard line on bond, ordered her remanded to jail, and made it clear that repeated violations cannot be brushed aside just because there is a sympathetic explanation behind them. But the court also left the door open for a fuller evaluation through the PSI before making final decisions on the underlying domestic violence resolution. That is the broader lesson here. In court, pain may explain behavior, but it does not erase accountability. If you found this case as intense and complicated as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.